get started, everybody, huh? Good to see everybody here. Thank you all for joining us this evening. Welcome to the Atlanta Federation of Musicians Night School at the Hall. My name's Aaron, and this monthly program brings together musicians and industry professionals to discuss topics impacting working musicians, no matter their union affiliation. Night School at the Hall was created by our union's organizing task force with the mission of better serving and understanding our community. We're here to advocate for the dignity, respect, and working conditions of all musicians, and we hope today's session helps us all learn and grow this understanding. We're thrilled that you're here. Thank you for coming. Our panelists today, some of the topics we'll be exploring, of course, generative AI music and the ramifications, possibly discussing the ramifications of generative AI on the music industry, what is being done on Capitol Hill to curb the free reign of generative AI, et cetera, et cetera. Afterwards, we'll open the floor after the panelists have a chance to talk with our moderator, John McCutcheon, for a Q&A session. If you have a question or a comment, go ahead, raise your virtual hand, or you can type your question in the chat and we'll call on you in order. Thank you all again for being here today. And without much further ado, I'm going to hand it over to John McCutcheon.
Hi, folks, and thank you so much for being here. There's a lot more folks scheduled to jump on, and they'll do it as Aaron lets them in. AI is all over the news, everywhere. It's on your phone. Correct me if I'm wrong, but I think the Beatles, with some generative AI, had won a Grammy at last year's Grammys. It was one of the things that our sister union, SAG-AFTRA, was most concerned about in their strike a couple of years ago, and we are at the cutting edge of the consequences of generative AI. So we hope that the three panelists who are with us tonight, who come from different parts of the community dealing with this, will help answer some of your questions, give you some information that you may not have thought about. It's an important and urgent issue in the musical community. And as Aaron said, and I will say it as more people join, if we're going to have some Q&A toward the end of the session, and if you want to be submitting a question, raise your virtual hand and Aaron will sort of wrangle all that, or you can type it into the chat. Let me introduce everybody. First, we have a member of our local, the Atlanta Federation of Musicians, Stephanie Tuck. She is a freelance trumpet player and is a creative advocate and has been doing a lot of deep diving into what this means for creative artists. Ben Kessler is the AFM's legislative director. He works on with issues on Capitol Hill, and that's going to be part of the equation as well. And finally, Robert Meitus is a well-known and highly respected music attorney, works only with the best clients, and he's my lawyer, and has been doing some workshops in AI as well. So, Stephanie, why don't we start with you? Talk about the work that you have been doing and the concerns you bring to this issue.
Yes, so my name is Stephanie. Like John said, I am a freelance trumpet player in the Atlanta area. I'm a local member. I've had a big interest in generative AI ever since it kind of came on the scene back in 2023, around then. I've been really interested in the repercussions that generative AI will be having on our creative professions. I've been trying to research exactly how these machines work, how they use people's data, what kinds of conversations are going on about maybe putting more data rights protections in place, especially for copyrighted data, researching, possible licensing regimes that we might be into, and also looking into ways that we as creators can protect our data and control who gets to use it in what ways. So that's kind of where I'm at and what I've been up to. John, you're muted.
People try to do that for years. Ben, you're the point person for the union on Capitol Hill. Can you sort of bring us up to date on what's happening there?
Sure. So without going back too far into the past, I think of my work both as playing offense and defense. Copyright and intellectual property protections are partisan. There are Republicans and Democrats who are with us on these issues. There will be Republicans and Democrats who are not. So when I talk about the things coming out of the administration, it's not reflexively partisan, but just the reality that we're dealing with of where the Trump administration happens to be on these issues. When it comes to defense, one thing that we were able to achieve, and anyone who participated in helping to defeat the state regulatory moratorium for regulating AI, thank you for doing so. Hopefully, if you didn't receive our Action Network petition on that, check your whatever email you have set up with AFM, check your, making sure that you get that. If you did, thank you for being part of a really broad coalition that helped defeat the state moratorium 99-1 in the Senate. The issue is that continues to rear its head in various forms, most recently with the White House AI Action Plan, Ted Cruz's regulatory sandbox proposal, which effectively says you go over here, play in your sandbox, and create generative AI without any interference from regulation. Whether or not that's actually copyright or just environmental policy kind of remains to be seen. But so there's defense to be played in what's coming out of the White House, and thank you again for participating in that. We saw, and we were just talking before everyone signed on, the attempted firing, and we still are seeing the Register of Copyrights share Perlmutter, just and the way that the sequence of that, you may have heard me talk about this, was and the why it's so deeply ingrained into what we do as protecting creators' rights. We saw the firing of Dr. Carla Hayden, who was the Librarian of Congress. The Copyright Office is within the library. So once the librarian was fired, the dominoes might fall and the register could be fired. So Dr. Hayden was fired on a Wednesday. On that Friday night, we saw the release of part 3 of the Copyright Office report on generative AI. And the reason that was so important was it really talked about the legalities of generative AI, and it stated what we all know to be true, those who stand with creators on these issues, is there's no such thing as blanket fair use. A fair use analysis is case by case. And that means that you cannot say that every time that your work is ingested into generative AI, into machine learning, that's a fair use. That does not exist, is what the Copyright Office said. And that report was published on a Friday, and pre-publication by that Saturday evening, the Register of Copyrights, Shira Perlmutter, was fired. So we see the attacks coming from the Trump administration, and again, not partisan, because of what we see in Congress, and we have some really conservative champions in the United States Senate. So just walking quickly through our legislative priorities, starting with the TRAIN Act, and the TRAIN Act would give subpoena power to a good faith rights holder to determine whether your work is being used in machine learning. And we have Senator Welch, a Democrat from Vermont, joining with Senator Josh Hawley, Republican, as conservative Republican as there is in the United States Senate, Republican from Missouri, Senator Marsha Blackburn, again, a conservative Republican from Tennessee, Senator Adam Schiff, a pretty progressive member of the United States Senate from California. Couple the TRAIN Act with that subpoena authority with the CLEAR Act, which we're looking forward to Senator Schiff reintroducing. He had a provision in the House when he was a member of the House of Representatives called the Generative AI Copyright Disclosure Act. Now it would create a registration requirement for anything that I'm using in my machine learning. So if there's a registration requirement, that assumes a good faith AI developer, right? I'm not gonna, if I'm just creating deep fakes and trying to mislead the public, I'm not gonna register anything I do. So we have that registration requirement, hopefully with the Clear Act, with the subpoena power of the Train Act. Those two things go together. I'll run through two more things. Notice a lot of information, so glad to get it out via email for everyone participating. But just throwing couple more things at you. That's the AI Accountability and Personal Data Protection Act. So thank you, Stephanie, for previewing that a little bit. Again, that's the aforementioned very conservative Josh Hawley from Missouri with Senator Richard Blumenthal, Democrat from Connecticut, former state attorney general, coming together in bipartisan fashion. And that would create a private right of action, a federal tort for when copyrighted materials are used without clear affirmative consent. And the reason that's so important is, from my perspective, is that we were always told by Republican members of Congress that creating that private right of action, creating that harm for when copyrighted materials are used was a non-starter for Republicans, for more conservative members of Congress. And having someone like Senator Hawley stake claim as he's going to be our conservative champion on this is a really big deal. So when we have those kinds of things come out of the White House, he's our guy to play that defense with us. And then lastly, excited for we're going to have definitely bipartisan introduction in the House, looking for a Republican senator to co-sponsor the Protect Working Musicians Act, which would create an antitrust exemption to allow independent musicians to collectively negotiate both with AI developers and streaming platforms. So those are the major pieces of legislation that I'm tracking that I think most directly impact AFM members and working musicians. We also support the No Fakes Act, which would strengthen your right of publicity in your name, image, likeness, and the sound of your voice. So just know I threw a lot out there, but thanks for the time, and we'll make sure that this information goes out to everyone.
Thanks a lot, Ben. That's a lot to digest, but it's emblematic of the kind of work that Ben and the union are doing on the legislative level. Robert, floor is yours.
All right. So I am a music lawyer, and for over 20 years represented primarily musicians, some other creatives, filmmakers, companies that are doing creative things, but mainly on a day-to-day basis, we represent people like the estate of John Prine, John when he was living, Sufjan Stevens, big rock bands like Cage the Elephant, or old bands like the Alan Parsons Project. So all different types of music, a lot in Americana, work with John, folk artists, and we think about AI, but to be honest, on a daily basis, we're not like fighting battles like you would be legislatively, or if you were working on any of the cases that are in various courts around the country. We think about it academically because I teach at the law school here, and we run a conference on it. But right now on the ground level, I'm here to tell you, and I think, Stephanie and Ben can talk about this too. There's a lot of worry, but there's not a lot to do for musicians. But what I can say you can do is contractually, if you're signing a record deal or you're doing any type of license, one way to protect yourself would be to put in a clause that says no scraping, no use of my data, no training. Now that's difficult on a case-by-case basis to enforce that, but at least you'll have a contractual right, a breach if somebody signed you and did that. We just did one big record contract, the biggest one we've done so far, and there was no pushback on that. Another thing you can do is look for organizations like Sound Exchange, just came forward with sort of a AI sound recording registry. You might have heard of this. The Sound Exchange announced the Global AI Sound Recording Registry Initiative last fall. It's now allows you to state whether your recordings are reserved, contact the rights owner or not indicated, 3 different levels sort of whether you're willing to have your works used for training and any purpose. But really what I'm here today to talk about is sort of the worries, the case law that's developing as we talk about this topic, and just to give you any input I can. I guess the big case lately is Anthropic, where there's a $1.5 million billion-dollar settlement, sort of shaped by the fact that there were two rulings that it was fair use. If Anthropic had obtained the copyrighted works legally, which they hadn't, but they could, you could license the work, then you could scrape and train, and theoretically, in that case, more literary works would have been deemed fair use in those courts. So that's kind of scary, and we can talk about whether music should be different, whether we can show market harm better, but the case law is not headed in the right direction particularly. So as representing an artist, the question is, do you, through private bargaining and through contracts, do you try and put yourself in a better position forecasting what you think legislatively might happen or not happen, and what you think the direction of the court decisions will be? So that's what I'm here for, and we can kind of continue throughout the hour talking about that, what individual musicians ought to be thinking and doing.
Thank you, Robert. Can you dig a little deeper into that as far as what musicians can and should do?
Well, one thing they could be thinking about doing is joining class actions and joining actions if you're a better known musician or you're part of a label group. I don't know, Ben, you probably know this better than I, but I haven't really heard of the musicians playing that big of a role in this litigation as opposed to the labels and the publishers. Like Concord has a huge case, right?
So it was just today, I think the first time that I've seen a case against AI developers and independent musicians bringing suit against AI developers. I think that was, but among how many cases are we at? 53 cases, 54 cases? I've lost more than 50 cases. We just saw our first one where there are independent musicians bringing suit. I think where independent musicians lack the ability to bring suit is the lack of transparency in the system, that the big labels can more easily demonstrate harm given their saturation in the market. That's what would be my of why it's so difficult for an individual to bring suit because it's such a black box whether your work has been used or not at this point.
Well, also whether or not you have the right. So let me back into this. If you're signed to Columbia or Atlantic Records, you don't necessarily have the right to sue if you don't own the sound recording. Forget about the song copyright for a second. If you made a work for hire, and there's a question whether it could be a work for hire, but either you sign the rights or it's a work for hire, you don't necessarily have the right to enforce. You might have contracted that away, right, Ben?
Absolutely. I think that's right. And before we go forward, there's just a question, and I think we're answering just in the chat about you used the phrase that scrape and train, and just asking for a definition. Scrape meaning that we're putting a large blanket over the entire internet and using it all source material for ingestion into machine learning, training just as that step for creating outputs. Is that a fair definition?
I think that's right. Let me read something that's a little scary. So Judge Alsup's summary judgment ruling didn't fault Anthropic for training its AI on copyrighted works. Rather, Alsup, the judge, found that pirating copyrighted works to create a general purpose digital library for Anthropic to use however it wanted was not fair use. In another case decided at the same time, Judge Chabria in the same federal district, and where has that been? The Anthropic and...
Oh, beats me.
Okay, I think that's Ninth Circuit in the West Coast, ruled that Meta's acquisition of copyrighted materials through torrenting was not copyright infringement because the purpose of the acquisition was to train AI systems. Okay, this is the key. According to both of these, the training of the AI was not the problem. It was the way they obtained the illegal copies. And had they just obtained them, which could be a lot less than $1.5 billion and $3,000 per work, there were 500,000 works. If they had just obtained them legally, these courts would have said that was fair use. Um, so the scraping and the way in which they obtain the works could be worked around, right, Ben? And then if the courts say it's fair use for them to actually
Yeah.
train,
Do do
we
people
could.
know what when we're talking about fair use? Do people understand why we're talking about fair use and why that's so fair use as a defense to copyright infringement?
I think it'd be worth the while to
So
define that.
fair use is a defense. So what we would argue as our union, as we're that our policy and contractual position is consent, credit, and compensation for musicians. And it would be our position that ingestion, when you take a song and use it for machine learning, so forget about outputs for a second. When you take that work, that in itself is is copyright infringement and not a fair use. What tech is saying that it is saying it all should be a fair use. That was my reference to blanket fair use, that all generative AI should be a fair use. What the Copyright Office said is, well, the nature of fair use is a case by case analysis. So when we have, typically let's put generative AI aside for a second. You'd have two works of art, visual art, any copyrightable material you would do if the defendant is saying, well, my use was fair use, then the court is supposed to walk through a four-step analysis, and I put that in the chat. That's the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion of the work taken, and the fourth one, which we've seen most important in generative AI cases so far, is the effect of the use upon the potential market, or the shorthand of that being market harm. So that's why use analysis is so important, and whether or not if a judge says yes, fair use, or it would have been a fair use if you didn't use pirated material, that's why it's so important.
So, Ben, could you speak a moment about that importance of the fourth factor and how in any new technology, the market may not have matured yet, right?
Right. So I think thanks for the question and the prompt. I think so. What we saw in the cases, the meta cases, were literary works, and the judge said, "Well, what about this is harming your ability to one, license the work itself, or harming? So what is the market? It's the licensing market, and also your ability to do business." I think we could make the argument, and time will tell whether music is different. So we've seen in terms of the big fake now, I'm forgetting I always forget the name of the fake Spotify band, Velvet Sundown. Do I have that
Yeah,
right?
I think
So
so.
maybe that there's if there are works that were completely generative AI without any creative choices made, maybe you could say, well, the streaming platforms are the marketplace, and I'm having to compete with those. That's one. The second part of this is there, I was always taught that if you say no, or if you say no over and over again to licensing, that strengthens the fair use argument because there's no other way to use the work in question. So it's why I just would always caution people when we hear in the news, with the potential of the big labels settling in their lawsuits against the AI developers, or we say the big the business trade press is reporting about the big labels are negotiating with AI developers. We'll see what happens, but I'd exercise caution. Don't get upset yet. There might be reason to be upset, but they're demonstrating that they're sitting down at the table in good faith to have some kind, to try and work out at least what a licensing regime could look like. Without those conversations, I think it would be nearly impossible to demonstrate the market harm that we're going to need to be able to demonstrate to win these legal
So,
decisions.
as an example of fair use, Stephanie, will you play along with me for a second? You were very
Yes.
young when Napster came about. I have a feeling you were quite young. And I was in law school because I'm an old guy. And And Metallica sued Indiana University, USC, and Yale. And I don't know if anybody remembers that, but it was shot across the bow. And the reason those schools were sued is because they were seen as sort of contributory infringing by helping the students. We were bragging about how fast our torrents were and all that. And so they just sued these schools. And there was the big decision by Judge Patel in LA in the Ninth Circuit went through these factors and struck them down one by one. So if I asked you to play along with me for a second, we said, what is the purpose of Napster file sharing, free file sharing?
Mm-hmm.
What is the purpose of that? What do you think the judge said?
To get copyrighted work for free.
Good.
So,
check one.
yeah.
Easy
Mm-hmm.
one. What's the nature of the underlying works that were being used?
The nature of the underlying works that were
All
being
the
used.
sound recordings and musical compositions, were they highly protected or were they thin copyrights like news stories?
I would say they were pretty highly protected.
The most valuable music out there, all of it, was
Mm-hmm.
being file
Mm-hmm.
shared without question.
Exactly.
What's the third factor? How much of it were they taking? Were they just taking samples, sort of like there are cases where they're just little thumbnail pictures in the Google case where they're just like showing little images, or how much of the music and sound recordings was Napster taking?
Nope, that would be the entire song. Yeah. So
Right.
whole thing.
And then was it hurting the market? There's a little bit of better argument on this for the Napster guys, but not really. Were they really hurting the market?
I think it's pretty clear that it was harming the market, seeing as how
If you don't need to
they
pay
were.
for it, you get it for free. Who's going to buy it?
Exactly.
So it couldn't have been more clear. It's almost comical to look back and think there was any question that every one of those factors fell in favor of the Recording Industry Association of America and the artists and the songwriters and the music publishers. Now remember that. We're going to come back to that in a minute, where I say the record labels, the RIAA, and the artists, and the music publishers and the songwriters, because those are two distinctly different groups. One's very corporate, one are the people we like to hang around, right? Okay, so that case was clearly not fair use. The defense failed outright, and the company fell based upon, that's where it really started to crumble. Here, in all fairness, this is more complicated, because when you talk about market harm, you can't really say that AI is directly making people not buy My Wife Carrie Newcomer's or John McCutcheon's music. You just can't. I mean, that's just not a great winning argument, that AI is directly keeping John McCutcheon's fans from buying his records because it's releasing John McCutcheon music. It's not. In contrast, you will have to make an argument that looks like what, Ben? How would you make the argument that it's harming the market less directly?
So if Stephanie were to, not that you would, Stephanie, if you were to license your work or at least engage in conversations, and there was a marketplace that someone could go if they wanted to use your work for AI ingestion, there is a marketplace that they could go, and instead they would be usurping the marketplace and harming the value of your licensing agreement would be harmed. I think that,
Mhm.
not suggesting that you should go license your work just in order to do that, but
Yeah, this reminds me of that you mentioned something about the market needing to mature a little bit for this, and that reminded me of a scenario, a hypothetical scenario that people talk about, especially in terms of like internet search, how generative AI by its nature may actually collapse the markets that created it. Because if you search on Google for something, it got all of its, the AI summary that comes up at the top, it got all of that information from the the web pages of everyone on the internet. Those people created those web pages because Google incentivized them to create them by giving them ad revenue. So if you take away the incentive for creating these websites, the websites may start to disappear, and then AI itself gets worse because now it doesn't have any data to use. And I think you can kind of cut and paste that argument maybe into the arts world. If there is indeed market harm, we will begin to see, human creators getting harmed and being less visible. And then that also may cause generative AI to get worse. So this may, I think, a selling point of this argument for licensing and for like ethical and responsible training is the fact that generative AI itself relies on there being a healthy marketplace for creative work.
That's very interesting. I'd not thought of that. To reiterate, there's the harm to the overall human market. I think that's a very interesting case to be made that will be difficult. It'll involve a lot of PhD economists in court, and not direct harm, but overall global harm. And then there's an argument that if we can see a matured license market for licenses, that you're harming by taking it for free what you would otherwise have to license. And when you think about it, the example of Napster, back then, part of their argument, I believe, was there's really no market for streaming music online. And we were so slow. It was 10 years. Can you believe that? Literally 10 years or a decade before Apple and Spotify really came in. I guess Apple a little bit earlier with iTunes, but streaming, certainly it was 2010 or 11, right? So a good decade that the industry took. So the slowness of the industry to create these markets in legal ways certainly doesn't help our fair use defense always.
And I think it's just as a reminder, right now we're just talking about inputs. There's
Yeah.
still copyright protection and what protects us on the output. That output could still be, and why we'd say there's no such thing as blanket fair use, that you could have an output that is in fact copyright infringement. So just keep that in mind. Just because inputs is decided one way doesn't necessarily mean
I
that
happen
we
to have an
agree with output.
experiment. Okay, so let's think of what a John McCutcheon Kanye West mashup would look like.
Yeah.
So if we thought about that, let's see if this infringes in any way, John. Can you see that?
Yeah. Yeah.
You're going to have to hum the melody in your head because these are just lyrics. But this is something that ostensibly is based upon John McCutcheon's works being ingested and trained into some generative, language model, right? And I'm not sure that it infringes any of your work, but let's look at it. Granddad's hands were leather and grace, built a house on a borrowed place. Told me, boy, don't measure your worth by the gold in the bank, but the dirt on your shirt. I learned truth ain't easy to sell, and freedom don't fit in a wishing well, but I still dream big, city skyline view, where the steel meets the soul and the sky bleeds blue. That's kind of scary, isn't it, John?
It's way scarier than what we came up with in Wyoming 3 or 4 years ago, which totally sucked, but I can see a lot of that. And I can hear Kanye doing it at the Super Bowl.
Do you see anything in there that you would say infringement? It took my lyrics directly in a way that
No,
substantially.
It's all attitude.
And do you see, I know your music and I don't want to say I do or don't. I mean, it talks about union halls and things that you might talk about, but sort of got some of your types of lyrics in it, right?
I've had stuff in recordings in the past. People say you need to get a lawyer, and my basic attitude was so and so has a lot better lawyers than I do. That's before I met you, of course. But yeah.
You see my point I'm trying to make, and
Yeah.
hope people are amused by that a little bit, but it's that the output wouldn't necessarily be infringing, but it's the idea that somehow they may have trained on your music, on your lyrics.
Well, that's how it works. That's how it would work. You asked to do something that sounds like me. Um, so one of the things that y'all have mentioned is licensing. And is there, in fact, licensing for AI right now? And if not, should we be on the forefront of creating something that favors us rather than letting that industry create it and present it to us?
So sorry. I was just going to say, I do know that Universal Music Group and Warner Music Group are currently at what they say is high level talks. I'm not exactly sure what that means, with several AI companies, 11 Labs, Suno, Udio, a couple of others. And they are specifically creating a licensing regime. It seems like it might be like the pro rata regime that something like Spotify uses. But they are looking to license their catalogs for AI scraping. And they seem like they're close to a deal that is as of the middle of October.
And I think one thing to keep in mind, what we at least saw from Universal, right, is that they would not even begin to consider licensing anything that would infringe on someone's right of publicity. That's their name, image, likeness, and sound of their voice. That's less to do with, of course, what we're concerned about in terms of what musicians' rights would be. I think also just to keep in mind is there a licensing regime that's even possible, given what the business is that the labels, what their business model is, which is selling human music. What is the price tag? Could you envision? And I don't have my brain power. I can't wrap my mind around what that dollar figure would be in order to actually get at the table and say, okay, you have access to our work. So I just think as you read those stories, remember they need to be at the table with these AI developers to prove market harm.
Remember 6 minutes ago when I said we'll come back to this, the corporations and the artists and the corporations and the songwriters, here we are. So when this happens, it doesn't go well usually. There have been class action settlements when, so what was really interesting, it's a great case to teach in my class every year, is that in the late 90s, Eminem's folks got smart and they said, wait a second, these downloads, and that does remind me that downloading Apple iTunes did happen long before streaming, right? So they said, these are licenses. They're not sales of records. And the difference in a record contract is that when you license something all the way back to the 1950s and 60s, the artist would typically share in half of the revenue. And when it's a sale, it could be, back then it was 5 or 6%, and it went all the way up to like 18, 20% of wholesale. Now there's lots of 50-50 net split deals, but throughout the years, it's been prevailed that sales would be a very low percentage. And the rationale was that labels would have so much money invested in marketing, manufacturing, and distribution that it justified a small royalty. But when they licensed something like to TV, like a sync, master sync license or something like that, or a record club, you would get a half of it. So what Eminem did was they sued and they said these are licenses to Apple. The people don't actually buy the copies of the CDs or vinyl, and they got 50%. And that led to class action lawsuits and then settlements across the industry. And I have some pretty big artists who got paid a pittance to sign off on that. And John, I think you know what I mean when labels try and do things for the industry's sake and helping the artist ends up getting a pittance, right? So there's this thing in contracts called breakage, not breakage like the old vinyl physical breakage, but it comes from that. But it's like what happens when Universal or Sony or Warner does a deal with Spotify and gets paid $1 billion. How much do the artists get? And that's what you said, Stephanie, prorated. But the problem is it never gets prorated in a fair way. It's always some de minimis amount, i.e. pittance, that the artist gets. So I don't trust the record labels and the publishers to do these deals with the Sunos and the Udios and the AI training and the artists and the songwriters to see much. I just don't. It's not going to happen. So I think the AFM needs to figure out a way to stand up for the artists wherever they can, and we as artist lawyers need to do the same. I'm not sure of how that works out, though.
So just to that end, I know that we postponed the town hall, but that AFM will be at the table with the labels through the SRLA, sound recording labor agreement. I don't want to weigh in terms of what that should look like because right now we're at the stage of hearing from rank and file musicians. So just if you are on this call, and I know this is open to all musicians, but if you are on this call and an AFM member, please do attend those meetings, weigh in with my colleagues who are forming what our goals at the bargaining table should look like. So I just don't want to say, it should look like this because I don't want to put my thumb on the scale for one side in particular. But so absolutely, so if you follow us on social media, I know there's Zoom town halls and ways that you can weigh in and making sure that your voice is heard. So when we're at the bargaining table, just keeping in mind too, and always happy to do these kinds of presentations, but what can and what can't we accomplish? These being work for hire agreements that we heard before. So there's some limitations, but really just strongly encourage everyone, if you think there should be an outcome or the AFM should have certain goals at the table through the SRLA with the major labels, please, again, follow us, AFM social media channels. There are town halls and ways for you to engage.
Aaron, could you send that? Ben, if I, for instance, got the notice, signed up, it was postponed.
Right.
Aaron, could you somehow let everybody who's on this call know about this because they really should be involved. It's really important.
Yep, I'm going to find the link tree. There's a link tree for this particular upcoming negotiation, and I'll be putting it in the chat here momentarily.
But I think, and there's a great and credit to my comms colleagues and others in electronic media who put together a where are we in the process and how it's step by step from now until negotiations. So definitely check out the social media. I think it's really good. 101, if you're not familiar with the process, even if you are, I think just as that reminder, it's some good materials on our social media channels.
I think you guys are probably already connected with Folk Alliance, but I'm on the board, and anything we can do to support the efforts or continue to support the efforts. I would love to spin off of this event and be more connected, John, with Ben and Aaron and whoever. We need to band together. We did write an amicus brief for the Vedder case, which is not really related directly, but I'll mention that will be heard next week in New Orleans. And this is a Fifth Circuit case on whether or not termination rights under 203 are worldwide, or they just US rights as have been assumed for the last 25, 30 years. And we wrote that amicus brief, and SAG-AFTRA signed on to it. It was MAC, a Music Arts Coalition, that brought us on, and then 5 different organizations, but not the AFM, I don't believe. I'm not sure why. I wasn't part of pulling those groups together, but SAG-AFTRA definitely did. And the point is that was something that if it would change the industry incredibly for artists, for musicians, songwriters, and recording artists, if the termination right applied worldwide, as it logically should under the Copyright Act. It's a long shot. I mean, it's entrenched right now, the belief that it's only domestic. But we need to all band together because against, the people who are on our side at the labels, who you work with, Ben, through these agreements like the SRLA, and on the other side, the tech companies like Google's, Amazon, Spotify's, Apple's, represented the huge money. It's very easy for the creators themselves to get lost and shafted. So whenever we get a chance, together we're stronger. So I'd be glad to play a bigger role in that, John, if I can.
Talking like a union man, Robert.
Well,
I-
we have to. Yeah, we.
I'm, I'm going to have to get you to join the local that your wife is a member of. So I want to get into some Q&A shortly, but I have one other question. Again, this is from the generated questions. What is the ideal world where AI and creators can coexist? Is there such a thing?
I think where there's consent, credit, and compensation in AI development, and that we understand that work that is created with in the chat, there was conversation about work that's created with a prompt, or in, copyright terms, is created without any creative choices. So that as I went on ChatGPT or I went on whatever, and I said, write me a song in the style of, if there is any copyrightability, the word we used when you were doing that exercise, that would be, the thinnest copyright imaginable. I think the Copyright Office is pretty clear. So I think if we just understand that basic, and that's really at the foundation of copyright law in terms of the requirement for a human author, and there's consent, credit, and compensation. And with that, I'll say also there's transparency. So the consumer of I'll say of AI tools, and the end user as the listener or the viewer understands that whether the work they're using is made entirely with generative AI. That's a lot. That's a pretty high bar. And tech, I don't think tech would say, "Oh yeah, sign us up, we're good." So, but that's what we're fighting for. And in the perfect blue sky, I think that's what it would look like.
Okay. There have been some stuff that has been put in the chat, and Jeremy, you've been talking about fake tunes and such as that, which is all AI. Do you want to ask a question here?
Yeah, I'm basically just interested in the overall opinions of these sites. I don't know if you've experienced any of them yet, but their renditions are convincing to even seasoned musicians, and particularly to non-musicians. And I'm wondering about what it says about the direction of AI music in this context. I think there's a lot of feedback that people are getting on these sites where, if you look at the comments, people are saying, "Hey, I would pay for this." But right now, there's no real mechanism to pay for it because it's technically illegal in a lot of ways, unless we think about perhaps in the pre-AI days, we would have what would be called a compulsory license to do a cover song. Would we see something like that happen in the case of these AI musicians or AI music compositions, which practically mirror the originals very closely, just in different styles?
Can we really quickly make sure everybody understands there's only a few compulsory license schemes in the music industry and in the Copyright Act, but do you all know the big one is 115 of the Copyright Act, where anybody can cover somebody's song as long as it's been published once and you don't change, the fundamental character of it. Although there's hardly ever any challenges to if you do a jazz version of Yesterday with a 15-minute sax solo, you're not going to be challenged. You just pay, and currently the rate is 12.7 cents per physical copy sold, and that's less relevant than the digital rate that is paid through to the Mechanical Licensing Collective, MLC. But the key is nobody can stop you from covering Yesterday by the Beatles. You just have to pay through ultimately to Sony and to Yoko and Paul, right? Mm-hmm. But there's a rate, and it's a bit of socialism, right, John? It's the government setting the rules and making people play ball by them. So one question would be: is there some compulsory scheme And how would you ever keep track of that? Like what, that would be difficult, right? Because it's not, that transparency word is important that Ben mentioned. Like when you cover the Beatles yesterday, everybody knows what it is, even if it has a 15-minute sax solo, right? You still know it's yesterday.
Yeah.
Uh, I'm not sure that a compulsory scheme would even be feasible. Would it be, Ben?
Well, I don't think, just not to interrupt, but I don't think you've heard these renditions.
Well, I
So
think
if you think
right.
of some of the hit classic rock songs from the 70s and 80s, these folks over at Fake Tunes, and there's another site called Fake Music, they're actually creating word for word, note for note, same, basic feeling. It's just they're in a different style. So they're one of the big things they do is they'll take all these songs and they'll do funk versions of them. So it's
So it
really
is
not
a
any different.
one, but it is a
Yeah.
115 compensated cover.
Yeah, it should be, but there's no indication that they're actually doing that. The only difference between what I would do with, some friends out in the garage to come up with this idea and what they're doing with AI is they can do it a lot faster.
And I
And
think
so
the
that's,
difference there, because in
yeah.
those instances, Jeremy, and correct, you're talking about where the sound of someone's voice is also replicated.
And at times, yeah,
But
at time now that they're skirting it pretty closely there.
right,
I
so
mean,
there
at
you
times,
have, I think you
yeah.
have a couple different, you have intellectual property kind of across the board, right? You have, and we'll never see, I don't think we'll ever see a compulsory license dealing with someone's right of publicity,
No.
Hmm.
right? That's some kind of dystopian sci-fi movie where you have to, give over to the government, but you get paid 12 cents every time someone uses the name, image, likeness, or the sound of your voice. So I think there's that. There's, if we're talking about that it's being marketed using band names in certain ways, right? We have,
Which it
there's
is.
there's a trademark concern potentially there.
Yeah.
There's other different, right? There's a lot of different intellectual property that I think, and the outputs might not be, if whether the line between cover and copyright infringement is thin there, right? Because if it is a straight cover, depending on the example that you give, the output could just simply not be a cover, but copyright infringement.
Yeah. So,
Right.
so, so Jeremy, I'll take a look at that. But my guess is if it's all streaming, there are mechanicals being paid. The thing about, you put it up on Spotify or a streaming service, and John, you know this, it's a pain to pay mechanicals if you release your own CDs or vinyl, right? Because you have to pay per unit sold distributed. Or you could do it at manufacturer. You don't have to, but a lot of people do it. It's easier. But if you put it up on Spotify and you cover a Pete Seeger song or something, you don't have to worry about it because it's all done automatically on the streaming service. So if this is on a streaming service, then it is mechanicals are being paid for the songs, probably, Jeremy. If it's
Mhm.
not, in 5 seconds we would have it taken down. That's a lawsuit if there are actual covers with no mechanical licenses in place. I'll bet you that part of it's licensed.
I just
Yeah, they
wanted
don't
to,
actually publish their methods. They don't publish anything about how they're doing what they're doing. So it's kind of a black box right now.
Okay.
so I just wanted to mention Spotify just recently expelled about 75 million AI generated recordings from their platform. And they are also, they are, what's the word? They're prohibiting any AI scraping of their library that is from external sources, from third party sources. That doesn't mean they won't scrape your work themselves, but they reserve that right for themselves. And I also wanted to say, because you were talking about a comment, Jeremy, that someone made that they would pay music for this this AI generated output. I might have old news on this, but I seem to remember that the Copyright Office was skeptical that AI generated work without sufficient human augmentation could be copyrighted. Like it may just go into the public domain because
Mhm.
there's not enough human authorship to convey a copyright.
Oh, Ben and I could speak to that. Absolutely. You wouldn't use the term public domain. There just is no copyright protection for AI
Got it.
generated components. Now, I wanted to bring that up. I'm glad you brought that up very briefly, and then over to you, Ben. Good luck, Copyright Office, in trusting people to self-validate what they created versus what they had their computer come up with melodies. I mean, they won't be able to, but there's guidance, and that's settled right now that they will not give permission. So it does give you some hope that Velvet, Sundown, or whatever, if that's all AI generated and it became a #1 hit, there's really nothing preventing 100 or 1,000 people from putting that same music up and competing with the original, because that's a little bit of a safeguard, right?
Right. And I think, so what's the importance of copyrightability? It's the ability to enforce your works and sue for copyright infringement. So what we just heard is, if you put up a work that's 100% generative AI, and I know, and I have some sense that it is, or it's been reported that it is, and you're making a ton of money, everyone will just replicate it. And if I'm getting paid right on some streaming service, the market will be destroyed pretty quickly. It's not stopping me. I mean, Jeremy, to your question, it's not stopping anyone. Someone could still buy it if they wanted to, but the market is quickly destroyed. So is there a market? Is there interest in creating that work if you can't protect it, if you can't enforce your rights?
Mm-hmm. Yeah, it's a sticky one.
Like, it's more just like, I would say it's more of a hobby than big tech getting actually into that work and competing in the marketplace with human artists.
I'm going along the chat here. Edmund, hey buddy, good to see you here. You had a question about, was the amicus brief for MAC? I guess this is to Robert.
Yeah, and the others signed on to it, so it ended up being for SAG-AFTRA as well. And we could do that as no other bigger law firm could, because they all have once in a while work for Warner or Universal or Sony. We never do. So virtually every big law firm wouldn't touch that argument because it will hurt the corporations.
Elizabeth asked, I would love to get your thoughts on DistroKid. Is that right, Elizabeth?
Yes, it's a recently new platform allowing people. That's where I think all of the Spotify music was coming from initially. It was allowing people to create and then monetize via this platform. But the legalities of that, I'm so unsure about. So I would love to hear your thoughts on that.
DistroKid is not new. It's been around for a long, long time. 2012, so 13 years. It's one of the more reputable aggregators, just like TuneCore, CD Baby does it as well. Just a way to get onto the streaming services. You can't go directly to Spotify. So DistroKid is, I don't know what they're doing, if they're doing anything positive or negative, but they're a reputable aggregator that gets you onto streaming. I'm ambivalent about their reputation. Anybody else have opinions about it?
And this includes everybody who's on the call right now.
Yeah. I mean, DistroKid is used by tons of my clients. I mean, it's just like TuneCore.
Yeah, I was just curious in the sense that they're not necessarily monitoring the type of music that's going on. So me personally, I gave it a shot. I made an AI song. I'm making money now off of said song. I'm a geologist. I have no business making money off of music, but that's one of the questions I had. I was just doing it to kind of see how the process works. But I was kind of floored by the idea that now our streaming platforms will be flooded, as you saw with Spotify, with AI music, and how DistroKid is kind of culpable in that, I guess, in some ways.
I mean, I could speak to that. There's a number of stories out there that have been picking on DistroKid because they had an automated process that they didn't require you to put in a record label name, and they would just default the record label name. So people were able to very quickly flood the system with AI generated music. Now, some of the other portals like CD Baby and some of the other aggregators have other checks in places. Not that they're any better customer service wise, but
Yeah.
the fact is that it could happen on any platform, and there's several people that have done exposés on that process.
Got it. That makes sense. So they're not putting up guardrails, and they're just trying to make a quick buck, perhaps.
Well, I
Got
don't
it.
think they were prepared for it in their defense.
Yeah.
Yeah.
Any other questions?
John Coons has a long one.
Oh, okay.
It's a full final exam hypothetical, maybe.
John,
We're
go.
getting Ben and I are getting nervous here. Um,
John, do you want me to read your question?
yeah, could you, John?
Sure. Hi, I have a specific question about royalty distribution for AI generated music based on a recent case. I don't have a microphone. Yeah. Here's the scenario in brief. A human creator wrote lyrics and invented an AI artist's persona. She used an AI tool, Suno, to generate the full musical composition and vocals. The AI artist now has millions of streams and a $3 million record deal. Here's the conflict. That AI company is now being sued by major labels who claim the AI was illegally trained on their copyrighted music. My question is, in a case like this, who legally gets paid the royalties? Does it go to the human creator who wrote the lyrics? Does the AI tools company have a claim? And if the major labels win their lawsuit against the tool, could they claim a stake in the royalties from the new songs that tool created?
I want to say it depends before anyone else gets a
I,
chance.
I had a better answer. I was going to say John Coons, exactly.
But I think we would go back to, I mean, I say it depends as a joke because that's always the right answer when looking at a hypothetical. But I think it really does, right? Because fair use is a case by case analysis. So what were those? So if we're looking, and that's why we need transparency, because you can't have a fair use analysis if you don't know what those inputs are or were. But you would walk through, in my mind, you would walk through the four-step fair use analysis, and the court would determine, is it a fair use or is it not? And I think looking, it seems as though in the beginning of the hypothetical that you have, how is the person described? So I would put this in my answer if this was law school. A human creator. So this is someone who is perhaps trained in music, who's making creative choices. Not to pick on you, Elizabeth, but I think it's a little different. If you have someone trained in music who's making certain creative choices about inputs, about what they're doing with that generative AI, they're gonna have a stronger argument for copyrightability. They're gonna have a stronger argument on the first step of the fair use analysis. So I think, again, I don't mean to joke, but I think it really does depend.
Yeah. So do we have to wrap up, John? Can I give one more
Oh, go ahead. Go
example?
ahead.
So we had this really fun case a couple years ago. A bunch of my students worked on it. It was, I wish I could say who it was, but suffice it to say that during the pandemic, producers got bored and one went on TikTok. And he said like the 30 or 40 samples that he used in this huge electronic dance band album that came out like 15 years ago. And you really didn't know what was used. And it's interesting because my client had a couple of tracks on there and they didn't even know it. Okay, so you would think that that would render a fair use opinion for a sound recording being used in a way that you can't even hear it. But actually in the Ninth Circuit, there's a Ciccone case. Madonna's horn samples were used. And it was so de minimis that the court said, yeah, that is fair use, or de minimis, similar to fair use. And in the Sixth Circuit, and Ben might know this case, there was a famous Bridgeport case where the court on appeal got it wrong. They misread the Copyright Act. It's still law down there. Any sample is de facto infringement. No fair use, no de minimis defense applies. It's a sort of a split in the circuits. It's never gone up to the Supreme Court. So we immediately copied that case, sent it off to the lawyers for this band and said, hey, this is a good place to bring a lawsuit. We used the law to get some sort of compensation for our client because they had used the sample, and they admitted it only by mistake or by idiocy on a TikTok. And when you think about it, like that's kind of similar to what's happening here. Like we don't really know if there's no transparency what they used. We can surmise they might have used something, Madonna or Taylor Swift, if it sounds like one of those artists, but you would have to go through the discovery process, would be hugely expensive. So to answer your question, John, it's complicated, but if you could go through discovery and find out that they trained on Taylor Swift and it sounded like Taylor Swift, you conceivably could beat a fair use case depending on the court that you end up fighting it in. Because until it goes through all the courts and gets sorted, there's going to be different decisions in the Ninth Circuit and the Second Circuit and all over the country. It's going to be a mess. That's why I jokingly said, exactly, all your questions kind of encapsulate how complicated this is going to be. And the lawyers are the ones who are going to be, happy because they're going to be fighting this out for decades, literally.
And I'll just, before we wrap, why we need Congress to pass the Train Act to give subpoena power to those good faith rights holders so they don't have to clog up the courts in order to determine whether work was used in machine learning. They can just subpoena the AI developers and determine and then bring suit once they have a much stronger case in hand.
And I do want to point out that in the chat, John included that it was not a hypothetical case.
I say hypothetical just as for a soft spot in my heart for law school, not in a literal, it's only hypothetical, but as presented, a law school hypothetical. But I appreciate that. Yes, no, real example. Thank you.
I want to ask Ben, you have used the word transparency, why it's important. What exactly do you mean by that? What would transparency look like?
We have to know whether your work is used in machine learning, or there is no fair use analysis if you don't know what work is used. Because, right, as Stephanie walked through and was asked, right, how much of the work is being used? Well, what work? Right, we don't know the answer to that. So without transparency, there cannot be. And I think that's why tech is fighting so hard against transparency, because they're saying it's blanket fair use. We know we need a fair use analysis. In order to walk through those 4 steps, you must have transparency, or we can't even begin to have the conversation. Is it fair use? Is it copyright infringement? Nobody knows.
Thank you. Before we close, I'd like to ask each of the 3 panelists. We've had a really, enlightening and vigorous discussion here. In closing, what would each of you say is an important thing for each of the participants here to do?
Well, I just wanted to mention getting away from all of the legal side and legislative side of it for a minute. Like, what are some tools or things that creators can do in the meantime to what's the word? To protect their current work. So the big thing I would say is read your platform's terms of service, especially, ironically, AI is very good at this. So if you take your terms of service for, say, Instagram or Spotify or YouTube or wherever you are posting content, and you put it into, say, ChatGPT, it can help you parse that document and find the places that relate to AI scraping. I do know that largely social media websites, if you have content posted on there that would fall, under data that you don't want ingested by AI, social media is largely a free-for-all as far as AI scraping goes, unless you put it as part of a private account. So you would want to be careful what you posted there. If you have your own website where you have recordings, sell recordings, or have other content, you might look into using Cloudflare. They are blocking AI scrapers by default now, and they're requiring AI scraping to pay a fee. So that could be a good way to protect your work. So just, be aware of the terms of service, use tools like Cloudflare, host on your own website if you can. Keep content that you don't want scraped off of certain platforms. And yeah, that was what I wanted to mention.
Thanks, Stephanie. Robert?
Well, I think those are great pieces of advice, and I would support the legislation that Ben has pointed out and stay in touch like I'm going to do going forward more with AFM's activities on that front. Let them tell me what I should be doing. I don't really know, other than that, what you can do. I mean, legislation, keep up to date, as much as you can on the topic, and support artists whenever you can. Yep, keep talking about it and keep it in the public conversation.
And Ben?
Thank you for that, and looking forward to working more closely going forward. I'd say engage in the SRLA process, educate yourself on where we are in the process, what AFM can and can't do in that process, and weigh in. So when whatever comes out of that bargaining, it's kind of like voting. If you're not going to participate and make your voice be heard, don't complain when it's all said and done. So do wait. This is the opportunity for musicians to weigh in with my colleagues who are hard at work getting ready for those negotiations, and make sure that you're getting, when we do Action Network and opportunities and asking you all to weigh in with members of Congress, please make sure that your email address, that you're getting all of those, and just so stay in touch. So SRLA engagement, and stay in touch with us, please, on our legislative engagement.
Well, I really want to thank Stephanie and Ben and Robert for the university's worth of information that you all have given us tonight. And in closing, Aaron, you want to talk a bit about when this is going to be available? And please tell y'all who have been here, this is going to be available in a month's time or so. And Aaron is going to tell us where. If you would like some of your colleagues to watch this and continue the education process.
Absolutely. Thank you all for being here. Yes, we'll get this up on our YouTube channel for those that would like to follow up, and absolutely forward. And like Robert said, just keep your ear to the grindstone. So feel free to follow us on our social media and our YouTube channels. I'll put it on the chat before we close here. But thank you all. Thanks, Robert, Stephanie, Ben. Great job today.
Yeah. And Robert, send me those lyrics.
I will. Thank you all. Great to see you.
Take care, everyone.
Thanks. Bye-bye now.